Okay. So very good evening to all the students. Let me tell you that your exam is upcoming in June 2025. For that, I have prepared a lot. Okay, and you can see the notes and all these marathons. Now, let me tell you what's the plan. From now till your exam, okay, which is your first subject you're giving, is your GIGL. Now you've seen my last attempts marathons. Also, I cover almost the full portion of GIGL. Okay, so I had got myself an exemption. Okay, that is above 60 marks in my examination for this paper, and I have taken one marathon. You can study from that, complete the chapters. For the other chapters also, I will be taking a marathon. So all today, tomorrow, day after, till the exam date, every single day I will be taking GIGL and I will be covering multiple chapters. Now, just today and tomorrow, today I will be covering the BNSS Act 2023, that was the Criminal Procedure Code earlier, and tomorrow I will be covering the Evidence Act, the BSA Act, which has repealed the Evidence Act. After today and tomorrow, then I will start with my bang on revisions for GIGL, where in one day I will cover multiple chapters and every single thing. The full paper will be coming from my entire marathons only. Full paper, every single thing, you can be rest assured. Okay, so I know everything by heart. I will take you all through everything and all the chapters. You can see on my GIGL the first marathon also, and you will realize that multiple chapters are getting covered and we are covering every single thing, including the past exam questions. Okay, so for today's agenda, let me tell you. Okay, today's agenda, I had done a part of BNSS Act earlier. It is there in the dream batch also. You all can enroll into the dream batch. In case you haven't, okay, the links will be in the description of the video. Okay, hundreds of students have already joined it. You can also join it. Okay, now before I start, I want you all to put in the chat box whether I am audible and visible to you all or no. Okay, then I will be completing the entire BNSS Act also. Clear? Everyone in the chat box, am I audible and visible? Okay, I had given you all access to all the lectures in the dream batch. Now I will be taking fast paced revisions. Okay, so I'm just waiting for you all to put in the chat box whether I'm audible and visible, so I can quickly start with my session. Okay, Chandan, what about others? Let me know. Okay, Siddharth, so can you take a marathon on share? See, company law, all the chapters. Now remember one thing, till now, till your exam gets over, I will be there hand-holding you, telling you the importance, taking you all through the marathons for every single subject, GST, company law, every single thing. From now on, every single marathon I will be taking. Okay, so be rest assured about that. Just be in my WhatsApp groups. I will be starting something called as a pre-exam marathon. Just before the exam, all the chapters I will be taking. Okay, so let's begin. Okay, so I'll give you a background about this act and then we start into the act directly. Okay, so hi, we will be starting with the Bharatiya Nagrik Suraksha Sanhita. What is it? Let's see. It has replaced the Criminal Procedure Code. What is a Criminal Procedure Code today that we will be studying is in case of crimes, what is the procedure to be followed by the police authorities? So how much, if an arrest is done, when we can arrest you, what we can, whether we can put handcuffs on you, how is the arrest procedure? Once you are arrested, then what is the bail procedure? Then once a bail has been granted, then if you want to settle it, what is a compounding procedure? So all that procedural aspect of a criminal law is covered under the earlier in the Criminal Procedure Code, and now we'll be calling as the Bharatiya Nagrik Suraksha Sanhita. Okay, so every law, okay, one can be divided into two categories. Either it will be a substantive law or it will be a procedural law. Sir, what is a substantive law? A substantive law is some where the offense or the rights are defined. If they give you definitions, they give you powers, that this is your powers, Like in Contract Act, it's a substantive law. Constitution Act, it's a substantive law. Or where they tell you what is the penal provisions and the amount of fine, etc. Okay, like how we had the BNS Act, which was the Indian Penal Code. It tells you that this is a crime and this is the punishment. It defines punishments. It defines the act, offense, etc. Whereas a procedural law is basically what procedure needs to be followed. Okay, what is a procedure needs to be followed? So, if we go to see, the substantive law is your Bharatiya Nyaya Sanhita 2023 and the procedural law is your Bharatiya Nagarik Sunaksha Sanhita. Very, very simple. Both are super simple. Today, the topic of the day is your procedural laws. Okay, is your procedural laws. So, sir, what will be there in the procedural laws? The part 1 I have taken, you can study from the dream batch. Now we'll be starting with the part 2 where the chapter will be taken. So some part the basics I had explained. Now I'll be going into the detailed provisions also. Okay. So we are done till this section 35. Okay, we are done till section 35. When can arrest be done? Okay. So I'll be starting from beyond 35, section number 35. Till you're good to go, I want everyone to just put simple GTG in the chat box. GTG in the chat box and we start and we complete it. Very smoothly I'll cover the full chapter for you. Very, very smoothly I will tell you what comes in the exam. Everything. All I need you, and I'll give you markings also important, which you can also mark it. Okay. GTG in the chat box and I start and complete this chapter for you. Okay, quickly. Good to go. Sneha, great. What about others? Malviya, Mariam, great. Okay. Sona, great. Let's start. Hi. So now we start with the second part of the BNSS Act. Now the BNSS Act is a procedural law, the procedure that has to be followed in criminal matters. Now one of the thing is how the arrest will be done. While doing the arrest, in how much time after the arrest you have to be brought before the magistrate. For women offenders, whether a male can arrest or a female or police officer can only do the arrest. So that procedural aspect is to be studied. So when you see an arrest, you can see a person who is an accused. This accused, whether he can be arrested or he cannot be arrested. So it depends on the type of offense that he has done. Type of offense. Okay. So if it is a serious offense, maybe the police officer can arrest without a warrant. So police officer can arrest without warrant. Now when I say without warrant means what? Police officer can arrest a person without taking a permission. Warrant means permission from the magistrate. Obviously serious offenses it will be there. For non-serious offenses, which is not that serious, police officer cannot arrest without warrant. Okay. Now warrant means the permission of the magistrate. So if any time police is coming to arrest, you can see what is the offense. If it is serious means what? Cognizable. The word is cognizable, and non-serious means NC, non-cognizable. So cognizable offenses, police officer can generally arrest without a warrant. Okay. Now we'll be seeing some of the provisions. Okay. So we are seeing that a new subsection was added in section 35, okay, which talks about when a police officer will arrest. It says that there are different hierarchies of police officers. Can the lowest level of police officer do the arrest, or arrest should be done by a certain person? So they say that no arrest shall be done without the prior permission of an officer not below the rank of a deputy superintendent of police. Okay. Where the offense is imprisonment less than 3 years and the person is infirm or above 60 years. So what they are saying, that a new section has been added, that a police officer cannot arrest except he takes a permission of the superintendent of police. He has to go and take permission of superintendent of police when you want to arrest a person for an offense which is not very serious. So not very serious means what? It is not imprisonment. It is not punishable with imprisonment greater than 3 years. It is less than 3 years. Means some small little thing you have done. So to arrest a person for this small thing, then they'll say go and take a consent of a senior police officer. Second, if a person is senior citizen, a person is a senior citizen or above 60 years, again we will say that you cannot arrest them without the consent of a senior. And third, if the person is infirm means weak, maybe paralyzed or having some medical condition, you cannot arrest them except without the consent of a DCP, the Deputy Superintendent of Police. Okay. Now let's say if a arrest is to be done. Okay, if a arrest is to be done, then what measures are to be followed? So now we will be seeing certain measures to be followed when the police officer are using their power under section 35. So what is the section 35 talking about? It is talking about arrest. So while doing the arrest, it's a procedure, right? While doing the arrest, what things has to be followed? So very first thing is where the section 35 states that no police officer shall, in all cases where the arrest of a person is not required, issue a notice. So where arrest of a person is not required, you don't need an arresting a person, so in that case you will issue him a notice, okay, directing the person against whom a reasonable complaint has been filed, against whom a credible information has been received, and against a person who is who has been under the suspicion of doing a cognizable offense. So what they are saying, that the police officer shall, where arrest is not required, and they will issue a notice and tell that person that listen, a complaint has been filed, or we have some credible information against you, or we feel that you have done a cognizable offense, and they will say you come before the police station. So if you go to see, this is very simple, where arrest is not required. Now let me explain. Normally, let's say if someone has come and they said they both are fighting, two people in the building meeting, they were fighting. Now police officer, normally this happens among all these people. So direct arrest and all of that is not needed. So they will simply call the person on phone if you go to the police station ever, and you tell them that some crime has happened which is not very serious. So then the police officer says that we don't need to arrest him, we will give him a notice. Maybe they will first call him up, they will send a notice to your house that either we have some information that you've done something wrong, or someone has complained, or we feel that you've done something cognizable offense. You please appear before the police station and answer. Now to whom this notice is issued, it is their duty, common sense, to appear before the police station. If you go to see, this is very common. Normally when a fight has happened, just a normal brawl or some road rage is there, and you go to the police station, the police officer does not direct arrest. He gives a notice to the other side that you come to the police station and tell what all complaint is there against you. And that person is bound to come before the police station, and he has to comply with whatever the police officer is telling them. Okay. And the police officer shall not arrest you unless it is required. Then arrest in India. Okay. Now we are seeing section 35 was about arrest. Now it is about the procedure in arrest. Okay. In section 35 was talking about when a police officer can arrest you without a warrant, and some few points were given. Now we'll be seeing the procedure of arrest. What is the procedure for arrest? So very first thing is the procedure of arrest is covered under section 36. So section 35 is saying when a police officer can arrest without a warrant. Section 36 is saying about procedural aspect. So while doing the arrest, if you've seen any Hollywood movies, or you've seen any those where you see on YouTube, etc., where a police officer is coming and he's arresting all these people abroad. So he tells that I'm officer, he shows his card. So he has to identify his badge, that this is I'm police officer so and so. Okay. He will normally, since he's arresting you, he will also take certain witnesses so that they will say that yes, this person was doing wrong or I followed the procedure. So a memorandum of arrest will be made. Okay, so the very first thing is identification. The police officer has to identify his badge, okay, his name and identity, that he is eligible to arrest. Then he will take a witness, at least one witness, preferably a family member, okay, or any respectable member of the locality, and that will be normally countersigned by the arrested person. So what is it? The first thing is you will tell your name, then you will arrest the person, and then you will call a witness also, that tomorrow if court will come, any matter goes on, you come and you tell what all did you witness, what all did you see for evidence purpose. Now when you arrest that person, okay, when you arrest the person and let's say his friend or family member is not there, so right to inform a relative or friend. If the memorandum is not attested by a family member, let's say the family member is not there, okay, then we will tell the accused that you have a right to inform your friends, etc., whoever you want, that you've been arrested, so that they can come with the lawyers. So in the very next section they talk about like right of legal representation. So very simple all this procedure. So what is happening? First we are seeing when you can arrest without a warrant. Then we are seeing when a warrant is required. First, when all permission of court is required. Then we are seeing section number 36, procedure for arrest. I'll tell my name, I will get a witness's signature, and if a family is not there, then I will also tell you that you have a right to inform your friends and family. Obviously, the section 38 says that the person who has been arrested has a right to meet an advocate. Lawyer, legal representation is allowed, and during interrogation can the lawyer come, yes or no? So normally you get very scared. I don't know what all cross questions they are asking. Police is asking so many questions. So the answer is that yes, you are allowed to meet, but it cannot be throughout the lawyer will not be throughout the interrogation. So where any person is arrested or interrogated by the police, he shall be entitled to meet an advocate of his choice, though not throughout the interrogation. So throughout the interrogation he is not allowed the advocate, but you are allowed to meet him at least once. Now there was a case, a very simple case law, where Supreme Court said in Arnish Kumar versus State of Bihar, okay, that police officers have to mandatorily follow the procedural law for arrest, and they have seen many times police officers misusing their powers and not complying with the step-by-step procedure. So Supreme Court has said that accused person should not be arrested routinely. So you should not, bail is the rule, okay, and jail is an exception. So you should jail a person only when it is required, and mostly you should give a bail. You have to follow the procedure, that's the rule. So what they said, that a person should not regularly, police shouldn't just keep arresting people. Courts are also overburdened, and jails are also overburdened. So unnecessarily don't arrest. And while arresting, you have to ensure that all the preconditions for arrest must be fulfilled. So all the requirements to do an arrest should be completed. Next. Now when a person, we saw right from the sequence, okay, when police officer can arrest, when they require warrant, then while arresting he'll give his identity, take you, and then he's taken you in custody, and you've got a right of legal representation. You've got a lawyer also for you. Now what? Now obviously you're sitting in jail. So now your lawyer, your family, etc. will come for a bail. That bail means what? It is release of a person. For example, someone is in jail. So we will file a bail application saying that please release him. He has not done anything. He's an innocent person. He has a good track record. He's a citizen of India. He will appear before the court, and please release him. You take a surety. Maybe a surety could be a person coming and taking his guarantee, or a security. Maybe some cash bail, cash bond is taken. 2 lakh rupees deposit has been taken. So on those grounds, the court will release a person from police custody to private custody, that you can take this person on the requirement that this person will appear before the court when it is required. So if you go to see what is the meaning of the term bail, what is the meaning of the term bail? So bail is a release of a person, right? Release of person from where? From police custody to private custody, okay, upon surety. So upon surety that he will appear before the court and police officers whenever required. Okay, so now we are going to see that they're going to start off like arrest, when all, who all can arrest under now they're telling you to come to bail. They're just telling you first who all can arrest you. So what do you mean who all can arrest? So first of all, if I'm not giving my name to the police officer, or if some private person is there, so even a private person found that you were robbing and everyone, the public saw, they will all hold you till the police comes. So even a private person, citizens also can arrest someone if they found someone doing a crime, and they will call the police. Till then it will be there. So normally when theft etc is done, people catch that person, start beating them up also. So that is a arrest, right? Arrest by a private person or citizens, and they say that till police comes he will be kept. Now we're seeing section number 39. Okay, a police officer may arrest a person if he refuses to give his name and residence or provides false information. So normally the first step, the police will ask you, what is your name? And if you don't say as per section 39, you can be arrested only. Okay, then release of a person. Once you're arrested, okay, you can be released on bond, a bail bond, okay, with the obligation that you have to appear before the magistrate whenever it is required. That's the simple thing. Okay, requirement of Indian surety for foreign nationals. Let's say a foreigner was caught selling drugs in Goa. Okay, maybe Nigerian is there and he was selling certain drugs in Goa. So the Nigerian will be arrested. Now to release him, they will have to give a surety. A surety is a person who is taking your guarantee. That guy at least has to be a not resident of India. Okay, simple. So the surety has to be resident of India. Now one part is there which is about 24 hours. 24 hours. Now this we had read in the Constitution of India also, that moment a person is arrested, now police is arresting, right? So he should be brought before the magistrate having in the nearest jurisdiction within 24 hours. This same point comes for Constitution, in other things also, where same point is given, that Constitution says, see, your Article 22, okay, says that the Indian Constitution requires the arrested person to be produced before the magistrate before 24 hours. So it is your Article 22 saying that within 24 hours you should be presented. Okay. Now, can a private person do an arrest? As I told you, that if you've seen some crime happening, okay, so obviously you can also go and arrest a person. So a private person means a normal person, not a police officer, may also arrest a person if he finds that an individual has done a non-bailable, cognizable offense in their presence. So if I see a person taking a phone and running away, we can go and arrest him and keep him. Or we find a person who is a proclaimed offender. Proclaimed offender means the government has said that this person is known gangster. You have found him, you arrest him till the police comes. And the job, very very important, this I feel can come in your exam. Okay, so this can important from exam point of view. Section number 40, arrest by private person. Now once the private person has arrested a person who is suspected to have done a crime, then you have to, the private person should hand over the person to the police officer within 6 hours. Okay, and he will be taken to the nearest police station. Okay, so how much hours? Within 6 hours you have to take him to police, to the police. Okay, within 6 hours you will take the person to the police. Now arrest by magistrate. Now we saw till now, what did we see? Police officer arresting. Now then we saw private person arresting. Now in the presence of a magistrate, if you have done something wrong, then if a offense is committed in the presence of magistrate, in the courtroom only, you've come and you started hitting each other, or a gunshots have been fired in the police, in the eyes of the magistrate, in the front of the magistrate, then the person can be arrested. So if you've done, the magistrate will ask the police to arrest you, and he will decide whether to leave you on bail or no, depending on how grave the act has been done. Okay, so authority to order arrest at any time. The magistrate may at any time arrest and direct a arrest of a person within his jurisdiction if there is a competent to issue a warrant, if they are competent to issue a warrant to the of the arrest. So now magistrate has a right to tell that go and arrest this person. So a magistrate may direct the arrest of a person, that they will say that go ahead and arrest. Obviously the magistrate has the power. Now while doing the arrest, okay, now this is very interesting, this is also important. Okay, now while doing the arrest, we see police officer punching, kicking, beating. Can they do that? So in the act, what is given in the act, they have said that yes, you have a right to touch, but you don't have a right to kill or use excessive force. So only what is required. Let's see what the law says with respect to while doing the arrest, touching a person. So physical contact, and what especially when it comes to women accused, whether a person can touch, whether a male officer can touch. Let's see the rules. Okay, so with respect to women, it is very important. A police officer making an arrest must actually touch or confine the body of a person. Means, you know how they put it, a person against the wall, that's confining, that's pushing against the wall. You can do that, okay, unless he voluntarily is submitting to the custody by word or action. So normally if you tell the police officer that you yourself put your hand and go down, then they will not touch you. But if you are resisting the arrest, police officer has a right to touch or confine the body of a person. Now most important, what if it is a lady, it is a woman? Okay, so can a police officer touch a male police officer, touch a female accused? Yes or no? Just touch. Answer is not allowed. A women's submission to custody. So let's say if a lady is there, she herself has put her hand down and said, I'm ready. So it is presumed that she is agreeing to the arrest. If the lady is there, she herself is saying that I'm ready to go. So it is presumed that you don't need to go ahead and force her, touch her, etc. Unless the police officer is female. Now see this line. Unless it's a female police officer shall not touch the person of women to affect the arrest. So normally police officer will not touch the woman, okay, unless it is a female police officer. Unless in extremely extreme cases, then it might be justified, court will decide. Now force is also whether it can be used. So the answer is yes. If a person if the person is forcibly resisting the arrest, then force may be used. Okay. Now another important thing which was not there in the earlier act, and this is very, very important and come in your exams, the use of handcuffs. Sir, what is handcuffs? Hatkadi, when you put the person in handcuffs, that time when can the police officer use handcuffs? Very important. Okay, so we'll learn the points also. So a police officer may use handcuffs, okay, while making an arrest, okay, in case where the accused is a habitual offender. So we know that he is repeated offender. Second is trying to run away, then you can use the handcuff because he is running away. Third, he has done an organized crime, terrorist activity, drug dealer. So you will do. Fifth, or is in possession of arms, ammunitions. And fifth is accused of murder, rape, acid attack, counterfeiting notes, human trafficking, sexual offences, etc. So in all these cases, you may use handcuff. So what are the points? They have given you around 4 points. Habitual offender, you're trying to escape. Okay, you're done some terrorist or organized crime or murder, rape, and multiple offenses has been given, we can learn and write it. Okay. Now again, with respect to women, one more point is there, which is very important. Okay, very important. So you can club both the points with respect to women, that no women shall be arrested between sunset and sunrise. So can I say it's somewhere in the night after sunset, before sunrise? So during that time, okay, let's say sunset is at 7 p.m. and sunrise is at 5. So from 7 p.m. to 5 a.m. arrest cannot be done except in exceptional cases. This is one. Second, in case the women police officer must prepare a written report and obtain prior permission of the magistrate before making the arrest. In such cases, okay, when you want to arrest, the women police officer must prepare a written report and obtain prior permission. If you want to arrest a person by night, then you will have to go take a permission, okay, of the magistrate few days, that listen, we will go in the night and arrest. So in the day, the police officer can go to the magistrate, take the order, and then the women can only come and arrest. Okay, so these 2 points you can remember. Now let's see. Now we come to search. We'll come to a very important topic called a search warrant. Now once the accused has been arrested, then the question comes that, listen, we've arrested the person. Now it comes about evidence finding. Now we have to get evidence. So we'll tell that, where did you keep all the stolen property? He said, no, I did not steal. He said, no, tell me, where all did you, where were you last there? Where did you go? Now I want to go and do search places. I want to search what? Search places. Why would you want to search places? One, to find, evidence, etc. So search of place entered by a person to be arrested. Section 44. So I want to search a place where the accused has entered. So power to enter and search. So does the police officer have a power to enter and search any place? Okay, for arresting a person who is suspected of hiding. So one is, why would you want to do a search warrant? Search warrant means a permission. So warrant means a permission. So warrant is a permission. So you want a warrant of searching. Now what do you want to search? So you want to search either the person if he's hiding, or if he's hiding any object, then maybe if you've some stolen property you want to find out, or any document. So search can be ordered by magistrate. Common sense. Okay. Now all these points will come for that only. Okay. Now pursuit of an offender outside India. So pursuit of an offender across India. So can a police officer be authorized to pursue an order anywhere in India? Yes or no? So section 45 is giving extrajudicial power that a police officer is authorized to pursue and arrest an offender anywhere in India, even if it is outside their jurisdiction, for the purpose of effecting the arrest. So first we will see anywhere in India. So police officer is there outside his jurisdiction also, if he is seen, he can go and arrest. So this we are seeing anywhere in India. So maybe if a Punjab police officer is there and he is just traveling and he sees something wrong in Chennai, he can go ahead and arrest. So a police officer is authorized to arrest an offender anywhere in India. Simple. Now similar point they are saying that producing the accused before the court, we've already done. Within how much time we have to produce it? Not exceeding 24 hours, excluding the travel time. Means what? This we had done, right? Constitution of India is also saying that once a police officer is arrested, then within 24 hours he will be brought before the magistrate. Now I'll give you an example of excluding the travel hours. Okay, excluding the travel hours. So obviously if traveling will only take time, then that will not be counted. For 24 hours means what? We'll exclude the journey time. So if a person has been arrested at 8 a.m. on Monday, okay, in Delhi, so a person has been arrested in Delhi and warrant is from Mumbai court. So Mumbai court had told that go anywhere in India you find him, go and arrest him. So So they found him from Delhi. That guy ran away, so they found him from Delhi. Now to bring from Delhi to Mumbai will take you, let's say, 6 hours. So will we count the 6 hours? So this 6 hours of journey time is excluded, and the accused must be produced by 24 hours plus the travel time. So obviously you're not including the travel time, so 24 hours is there. So if I have to arrest a person, I will think that I arrested him. Now journey time is 3 hours, so I don't have to worry. So I can exclude that, and I will have additional more time, 24 hours, to go and produce him before the court. Now if you want to detain a person, you can when a person is arrested without a warrant, cannot be kept in custody beyond 24 hours and must be produced before the magistrate. So this we've already done. The magistrate may authorize the detention for up to 15 days. So now if he has been arrested and produced before the magistrate can increase his jail term, or we can say judicial detention. They will say they want to detain him, so 15 days they can authorize. If further detention is needed, it can be extended to a total of 60 days or 90 days depending on the nature of the offence. So maximum 90 days it can be there. Initial thing is 15 days, and then after that is extension till max 90 days. Now simple, they are saying that a police officer, now this is not for you and me, it is for the police officer. Now the officer in charge of a police station, so whichever police station is there, they will make a report of all the arrests that they have made without a warrant. So entire reporting will be made and given to the magistrate from time to time. And no person who is arrested can be released except on a bond, bail bond, etc. Okay. Rearrest. Now what is the meaning of rearrest? So if a person has escaped the custody, he can be rearrested, and if he is anywhere in India, arrest them anywhere in India. So if they have this persons who break the jail, so they can be arrested from any part of India. Very simple, nothing great. Okay. Now we come to, till now we saw all about arrest. Okay, arrest, private person, women arrest, all those things. Before 24 hours we have to bring the accused. Okay, what else you saw? When handcuffs will be put. So all we saw with respect to arrest when it can be done when you're not giving your name. Okay, arrest by private person we saw. Now the second important part is coming, which is called as summons and warrant. Now summons and warrant cases are very, very important to know. Okay, so summons cases are one and warrant cases are another. Warrant cases are serious offences, and summons cases are less serious. Clear? Let's see what they have given. Now let's see here what they're talking about is summons. Now let me explain all the provisions. Okay, so one is summons and the other one is called as a warrant. As I told you, warrant comes from the English word which means permission. So to arrest you require, police requires a warrant, that is a permission. They require permission from magistrate. That's a warrant that a magistrate will give you for non-serious, non-cognizable offences. They will say that police officer will come and say that this person has done wrong, I want to arrest this person. So then the court, the magistrate will make a arrest warrant. They will make a arrest warrant. Now obviously warrant is a permission, so permission could be for arresting or for search also. So warrant will be given. It will be written against whom it is there. Accused details will be given. What offence he has done, that will come. The name of the court will come. Name of court, name of the magistrate will come. Okay, the seal of the court will come. Then what else can come in the warrant? Okay, now it will be like a letter that you are called. We are coming to arrest you. They'll come to your house, etc. and arrest. Now this will be like a place this warrant will be given. Summons is where the court calls. Summons comes from the English word to call. You can call a person or you can call a document. Okay. Now summons will be given, maybe if it is a company it will be given at the registered office. If it is a person it will be given at the home. Okay. If it is a government body then it will be given to the where the government office lies, head of department, etc. And they will tell that you are summoned, you have to come before and answer your charge. Arrest warrant is basically they come and they'll directly arrest you. So let's see the procedure to be followed. Let's see. Procedure for summons and warrant. Also what happens is first court gives a summons. Normally the procedure will be summons will be issued. Now imagine even after summons has been issued, you are not coming before the court. Then court will say this guy is not going to come on his own. You go, I am giving an arrest warrant, arrest him and get him. So first summons is issued that you please come and answer that why we should not take action against you. Now obviously a person who is done wrong will not come before the court. So after 1-2 summonses there, they will try to stick it, they will try to inform your family member, parents, etc., children, wife, they will inform a family member to say that the summons is delivered. So summons can be given to you or it could be given to your family or they will be sticking it anywhere. And if after the receiving of the summons also not coming, then a warrant will be issued for arresting you. Now summons. A summons is issued by a court. It will be in writing, okay, signed by the officer of the court. It can also be issued nowadays through electronic means and it will have a seal of the court. Service of the summons, okay. Who will serve the summons? Now summons is like an court order. So maybe the police officer can come to your house and issue it. If let's say this person can be given to you or to any adult family member. It can be given to adult. Earlier it should be written that adult male member has to be given, but now they have removed this gender bias and they have said that a summons person cannot be located. If I cannot find the person to tell him, then I will issue a duplicate copy to any of the adult family member. And the adult family member must sign the receipt of summons back that they have been informed that this person is to be come before the court. Okay. Now again they are saying summons to different person. Now if it's a body corporate, you will issue it to any of the officer in charge, okay, or to the registered office. Okay, if it is a firm, then again you will give it to any partner. Now, if it is a government or body, then it will be given to the head of the department, etc. Now, procedure cannot be affected where summons cannot be given because the person not staying at home only. Nobody is coming. Then a conspicuous path. This is called as a substituted summons. So, what is a substituted summons? A summons is basically court is calling you, but you are not coming only. You are not staying at home. So, how will we inform? So, then they will stick it. A duplicate copy of the summons on any conspicuous part of the house. Conspicuous means prominent, main door, they will stick it up. Okay, and they normally take a photocopy also of it. So summons will be given. Now the next thing is, imagine summons has been given. Now we are going in a very beautiful flow. Okay, it's everything given in a flow. First we saw the provisions of arrest, who can do, magistrate, private person, police officer, etc. Arrest. Then after the arrest we saw that after the arrest you can make a general for bail, a little bit provisions they've given you. Later part again bail comes. Then they will tell you that arrest is being done. So how will they do? First summons is issued. Summons is a letter that you come and answer. But if you don't come and answer before the court, don't appear before the court, then a warrant can be issued. A warrant is a order given to the police officer, go and arrest him and come. Now let's take a person who is a drug dealer. He has been given a summons, he didn't come and he ran away only. He is hiding somewhere. So even the warrant has been issued, but police officer cannot find him. Then what can we do? We issued a summons, he didn't come. We issued a warrant of arrest, but police officer think we can't find him. Then what to do? Then what they will do is they will attach his property. Attachment of property will be attached, because obviously now if some very famous offenders, if you know, They are not available. The police have never been able to catch them. So they go and they seize their property. And the last thing that the court does, so this is the steps that they do, is called as proclaim them as an offender. You put a prize money on them. Proclaim offender. Okay, that they say that if anyone gives information about him, they will get a 1 crore rupees from the government. Okay, so this is the steps that we are seeing. So section 64 to 69, 84 to 89 talks about a proclamation of a person and attaching his property. Now, and very nicely they have worded that a police officer cannot arrest you. The person was not found only. So how do they name it? That where a warrant remains unexecuted. That is, the police officer couldn't arrest you. So the warrant remains unexecuted. Police couldn't arrest. Then two remedies are there. Either we proclaim them as an offender or we attach and sell off their property to get the money. So very simple, that proclamation for an absconding person. Section number 84. That if the court has reasons to believe that a person against whom a warrant has been issued has absconded or has concealed themselves, so they are hiding somewhere, then the court may publish a written proclamation and ask him to appear before 30 days. And if he still doesn't come, then the court issuing a proclamation will then record in reasons and attach the property. All his bank accounts will be freezed, all his immovable property will be freezed, and they can sell the property and recover the money. That money will become that of the central government. Simple. Okay. Now, summons. Now, what is a summons? Very simple. Summons is basically, we'll tell you to produce either the document or the object. Okay. That first, initially, always the process is someone goes and complains, then court will say, okay, fine, let me call him. So they send a summons to your house. That's a summons. Okay. So we've already done all this. Now I told you warrant could be two kinds. Warrant means a permission by the magistrate. Warrant could be of two kinds. One is your arrest warrant, what we saw. The other one is a search warrant. Now very, very important, you need to know along with the section number. Section number 96. So what does section number 96 talks about? Search warrant. That the court may issue a search warrant in the following cases. That court will say go and search. Now when they will say, very important, I'm just thinking that when will the court say and go and search? So if I feel that someone has taken a stolen property and hidden somewhere where nobody knows where the property is, so we'll have to give a general search. Second, we feel that a person has hidden something and will not produce it, then we will do. Okay. Third, we believe that we don't know in whose possession it is. So all those cases the search warrant will be done. But search warrant is not issued generally on the government. Okay, government officials. We'll see post, etc. is not under section number 96. So let's read the provision. A court may issue a search warrant in any of the following circumstances: where the court has reasons to believe that a person to whom a summons or a requisition has made will not produce a document or the object. So first point is where the court has reasons to believe that when I have given a summons, when we have requested him to come requisition, he will not come, he will not produce it. So then we will issue a search warrant. Second, where we don't know in whose possession the goods are there. For example, a thief has come, he ran into a building, he hid the jewelry in someone's house. Now we don't know in whose possession that jewelry is. So we will issue a general, that search all these people. So when we don't know in whose possession it is, we will tell that search everyone. Next is where the court consider a general inspection necessary, then they will do. So 3 cases it is. Okay, section number 96. So what does section number 96 say? That when search warrant can be issued. So court may issue a search warrant if they have reasons to believe that a person who has to produce will not produce. Second, we don't know in whose possession it is. And third, a general search is required. Okay, as I told you that For government, they will not issue. Okay, so a search warrant, if they have reasons to believe that a person is used for depositing or sale of a stolen property or sale of any objectionable articles. Now this is search of places suspected to contain stolen property or forged documents. Similar to the earlier point only, that where can a search warrant be issued? When? Okay, so we said that when we feel that if they have reasons to believe that a place is used for selling the stolen property. So we feel that there are something called as Chor Bazaar. Have you heard? Chor Bazaar is basically one market where all stolen property is sold. So in that area also it can be issued, or where the sale of objectionable articles or stolen property is done. So in that area also it can be issued. Okay. Now power granted under a search warrant. So what all power has been given? Common sense. If I'm searching, I will enter the premise, I will search the premise, I will seize it, I will prepare a seizure memo that whatever I'm doing, I will take witnesses' signatures also that they have seen, present the seized article before the magistrate. After seizing it, I will present it before the magistrate and arrest any person found in possession of or trying to sell these stolen articles. So what are the powers of the police officer with respect to search warrant? They can enter, search, seize. So they can enter the place, search, seize. They can seize the property and they can even arrest the person. Simple. Okay. Now when they say objectionable articles. So what does objectionable articles means? Very simple. Okay. So objectionable articles under section 97 means, so we saw that search warrant will be done and we will arrest the person if we find them in possession of any stolen property or objectionable articles. So if a person has been found of any fake notes, fake currency notes, etc., okay, they can be arrested. If we find that forged documents have been found, false seals, company seals have been found, okay, metal pieces manufactured in contravention to the Coinage Act, obscene objects have been found, or instruments or materials used for producing any of the above. So if we found these are objectionable articles, any of this, if it is found, the police officer can arrest the person only while doing the search if he finds these things. Now we saw search warrant was there. Now we were normally seeing searching of what? Documents only. Now they are saying searching of a person. You have to find a person only who has been wrongfully confined. So for example, if we seen, we see all those movies where a child has been confined. So now we are doing search to find abduction cases, or you could say cases of what do you call, where a child has been kept in custody. Kidnapping. Okay, so kidnapping cases, etc. are there. So what are we going to find? We are going to find the person who has been wrongfully confined or hidden somewhere. So we'll tell that search this guy where this child is being hidden. Okay, so the magistrate may issue a search warrant if he has reasons to believe that a person has been wrongfully confined, or let's say if any person have wrongfully like all those drug trafficking, human trafficking cases are there where you hold a person, someone, child, etc. So that can be search warrant can be issued to identify the person, and they will be brought before the magistrate and proper orders will be passed. Now while doing this also, so normally all these cases are very serious where you're trying to find these persons for extortion, someone has been kidnapped, etc. So in that case, whenever the police is entering any place, they will start their video recording and take. So the recording of such search and seizure through audio visual means is important, especially when a person you're trying to find. The conducting, how you're doing it, what all possessions you're taking, all the seized items shall be recorded through audio visual means, or even mobile phone is allowed. Okay, nowadays when they come in for raid, they start a video camera and they come. the police officer must forward a recording without any delay to the magistrate. So normally when they come for search, seizure or raids, they normally come with their audio recording device also. Now we come with a concept which is called as summary trial. Okay, summary trials, let's understand the meaning of the term. So till now we were understanding all this concept about warrants. Warrant could also be search warrant and arrest warrant. Now we'll be seeing a trial, summary trial. Sir, what does a summary trial mean? Summary means in short. So this is for speedy settlement of disposal of cases. Speedy disposal of cases. So normally these are non-serious, or these are not very serious offences. So when it is not very serious, you will see only virtual offences are coming for which summary trial can be done. Quickly the matter will be done. In summary trials, detailed evidence finding and detailed procedure is not followed. Summary procedures are being followed. Quickly they want to end the cases. So let's see which all will come. So summary trial. A summary trial is a speedy settlement of certain cases. It applies to offences. Now will serious offences will be done quickly? A murder case can be settled quickly? No, for that proper evidence will be done. Summary trial will be where the theft has been done of 2000 rupees. So they will say, okay, fine, let's end it. Okay, where offences not punishable with imprisonment exceeding 2 years. So summons cases are those which are not exceeding 2 years. So that for summons cases, we can have a summary trial. Sir, what is a summons case? A summons case is a case where the offense for that act does not exceed, the punishment for that offense does not exceed 2 years. So this can be tried and disposed of quickly. So which are the matters? First of all, who can do summary trials? So the section is section 283. Following authorities have the power to do a summary trial. So it is Chief Judicial Magistrate and JMFC, Judicial Magistrate First Class. Now this is important, that which all offences can be summarily tried. So all small offences where stolen property of value not exceeding 20,000, where the property value is not exceeding 20,000, assisting for stolen property not 20,000, certain offences given there, just doing breach of peace, criminal intimidation, abetment of any of these offences, cattle trespass, animals etc. have come in someone's land etc. eaten. So all those things are can be quickly, speedy settlement can be done, speedy disposal can be done. Okay, now very important. Okay, so we saw that offences which are punishable with maximum 2 years, not exceeding 2 years, can be summarily tried. So more than 2 years offence, if it is there, cannot be summarily tried. Now while doing a summary trial, while quickly settling the matter, they cannot give a very harsh imprisonment to the accused, because we have not gone in depth. So fast track manner we are ending it. So they are saying that maximum punishment, okay, the offence is not punishable. A magistrate may, after giving the accused of being heard, decide to try an offence summarily. If the offence is not punishable for exceeding 3 years, reason for conducting a summary trial has been recorded and no appeal shall lie. So max 3 years, they will give the reasons. The magistrate, after giving an opportunity to being heard, will try an offence summarily, will settle the matter summarily, okay, and will record the reasons also. Procedure if summary trial becomes undesirable. So at any time if the officer or the magistrate feels that I don't want to settle it quickly because too many things are coming new, so then they will proceed with the normal procedure under the law. Now, very important, note this down. Section 285, that no sentence in imprisonment in summary trial can be given of greater than 3 months, shall be passed in any conviction. So max imprisonment that can be given, max punishment that can be ordered in, because we are quickly settling it, so we don't give a very harsh punishment. Max 3 months. So maximum imprisonment is 3 months. So even the accused is happy that okay, fine, yaar, in max imprisonment I'll get is of 3 years, so I also don't mind settling the matter summarily. So no sentence under summary trial, the magistrate cannot give an imprisonment greater than 3 months. Okay. Now we come to a concept called as compounding of offences. Compounding of offences means what? Normally, when an offender is there, okay, when an offender is there, he is an accused is there, he has done a mistake. Now he says that please, I'm ready to pay some fine, please settle the matter. Now normally some matters are private wrongs. Okay, so let's say there has been a fight. There has been a fight between Mr. A and Mr. B. Okay, both hit each other and there had been a fight. Okay, road rage, etc. And this guy got injury for which he had to pay rupees 25,000 medical expenses. Now he can go against him. Now court also says that okay, fine, you want, you can file and pursue in court and litigate, etc. However, Mr. B can say okay, fine, I am ready to settle the matter. Let him settle the matter by paying some compounding fine or compounding charges. So it is a kind of a out of court settlement. It is in the court. This only with the parties, they negotiate, they close and close the matter. Now very serious offences cannot be done. Some offences require consent and some can be readily compounded. Okay, so let's see. Compounding means settling the matter by paying fine. Okay, so what is the meaning of the term compounding? So compounding refers to settlement of an offence with the consent of the court. Parties can normally amicably decide outside the court. They come to the court, they say we both have agreed on these terms, court will sign and close the matter. Okay, parties do not wish to continue the legal thing, they can settle it through compounding. Okay, now offences that can be compounded without court permission. Now see, very small offences will be there. Voluntary causing hurt, 2 slaps was given to someone, he says pay me so much money, I'll close it. Wrongfully restrain someone, so if someone was just being restrained and they can be, both the parties are okay, then they will settle it. Assault, use of criminal force, theft. Okay, so all these things can be done without the approval of the court because it is mostly a private wrong to that party. So if the parties are only agreeing, then they can settle the matter. Now some which require approval of the court, okay, like causing hurt in the subsection 2, then confine a person in another thing. So all those, some of them will require breach of trust, require approval of court. Theft by a clerk servant in possession of his master. So a clerk in someone's employment is doing. Now, are all offences compoundable? Answer is no. Only few are compoundable. Serious offences cannot be compounded, which are punishable with life imprisonment or death. Okay, so anything in every law they have with respect to compounding, where the provisions differ from act to act. Means what? In FEMA Act there will be a different compounding, Companies Act there will be a different compounding, and in BNSS Act also there is a rules. What is the rule? What matters cannot be compounded? So for which there is life imprisonment or death, that cannot be compounded. Normally in the Act only it is written in the schedule whether it is compoundable, not compoundable, cognizable, not cognizable. So you'll open the Act and read, and then you will come to know. Okay. Then we saw bail. We had done what is bail. Okay, so bail is basically release of a person from private custody to police custody, from police custody to private custody upon furnishing of certain surety. Okay, 1. Now anticipatory bail. What is the concept of anticipatory bail? Here you anticipate arrest. What happens here? Anticipatory bail, you anticipate or apprehend. You apprehend or feel that I will be arrested. You have not yet been arrested. It is for a serious offense, cognizable offense. So before the arrest, FIR is filed, but I have not yet been arrested. So I will send my lawyer to get a bail and come and say that listen, there is not I have just been wrongly involved. I am not involved in it only. So let's say someone has complained. Let's say there is a case of cheating. Cheating case has been filed on partner A. Okay, some client has filed on partner A. FIR is registered. FIR is registered. Now, police is coming to arrest. So obviously now Mr. B, C, who are also partners, they say, oh my god, FIR is launched. It is possible that the police will come to our doorsteps also to arrest us. So they will quickly go to court. They will quickly go to the court through their lawyers and file for ABA, anticipatory bail application, that we have not been arrested yet, but we anticipate arrest. We feel that matter will go on and then police will come to arrest us also. We want to bring our case now only, and we want to argue now only that we are completely innocent. That is the concept of a ABA. Okay, anticipatory bail application. So before the arrest only you've come on basis of FIR has been filed. Why do you want to get arrested and then file for bail? Then file beforehand only. Okay, if you feel that yes, I will also be dragged into the case. So a person who is accused of a bailable offence without a warrant, okay, shall be released on bail. So a bailable offence, so you will get a bail as it is. Only for non-bailable, see, in bailable offence, you get a bail as a matter of right. I don't have to file ABA, etc. I will file the date someone has come, I'll apply for bail, I'll get a bail. Matters which are cognizable, serious offences, they normally will go for ABA. Let's see. Now they've also said that if a person is indigent person, indigent means what? Indigent means a person who is poor, pauper, doesn't have many money. So for them, court can waive off the court fees for him. Okay, and they can even say that he can be released without a bail bond. Okay, they will tell that, see, if someone can come for him, if he's not coming, he doesn't have anyone, so the court can release him also, which is there. Okay. Now anticipatory bail, I told you. If a person is apprehending arrest, is feeling that they will be arrested for a non-bailable offence, so normally they won't get bail. So for them, they will have to, so not bail doesn't mean that the court will not grant you bail. That means that the court will not grant you bail as a matter of right. You don't have a right to demand the bail. If you have, the bail becomes a discretion on the court. The court will decide whether they want to give you a bail or no. So in a non-bailable offence, you will appear to the court and say that, listen, I am not involved in the case at all. Someone else is involved. Please release me. Okay, so then the court can order, depending on the facts of the case, the release of a person even before being arrested. So partner B will say that, listen, I am nowhere involved. This is partner A only. Just because I am partner, everyone is jointly and severally be responsible, I shouldn't be dragged into the case. I didn't have any involvement in the matter. If it is found, court will order a bail. The person will be released on bail. Okay. Conditions for bail. The court can impose while giving a bail. They will tell that, listen, we are granting you the bail, but you cannot leave India. You can't go and threaten any witness, and you have to come before the police whenever it is required. Okay, simple. Now, let's say if a surety is there, you are given a surety's name. Okay, and that surety is a person who is saying that, listen, if he doesn't come, then I take his responsibility to come before the court. Okay, I will get him to court, don't worry. So parents, brothers, sisters normally take the surety for someone, that please release him, I will get him, don't worry, he's not done anything. If the surety dies, then what will happen? Then the court will order the accused to furnish a new security or surety. Okay. Then comes limitation period. So this is also pretty interesting. Limitation period is a time limit to appear before the court for any act. So if any wrong has happened, automatically the time will start. Within a certain time limit, you have to reach the courts. Whether for criminal cases, time limit applies, or it is only for civil matters. Breach of contract, within this much time I have to go to court. So the answer is limitation period also applies to criminal cases. Okay. Also applies to criminal cases. So limitation period also applies to criminal cases. We will see. Okay, they have given you some rules. First, they are saying that extremely serious offences do not have time limit, but for normal offences there are time limits that they have given. So they've given examples. So okay, so for punishment for an offense, so if in the act, if an act is punishable with fine only, then such an act should be brought before the court within 6 months. If it is imprisonment up to 1 year, then it should be brought before the court before 1 year. If any act, an offense has been done which is exceeding 1 year but not more than 3 years, okay, then limitation period is 3 years. So depending on how serious the offense is, the limitation period is decided. Okay, if multiple offenses are tried together, so murder, theft, beating up, then the limitation period will be determined by the most severe offense in that case. So we will see that if you've done murder and it is coming in no limitation period, then no limitation period will be given. Okay, commencement of limitation period, from when does it commence? So the relevant computing of the limitation period is the date of filing a complaint and date of recording the information. So commencement of limitation period is the date of filing the complaint. So maybe you filed, sometime you have to file before the police officers. So when does the period of, so let's read, now I'll explain that when does the period of limitation start. So it starts from the date of the offense. So moment, or you came to know from the date of your knowledge, okay, or your identity has been discovered. So in all these cases, the limitation period will start from that day. So from the date of the offense, the first day when you came to know who did the offense, or the first day of the knowledge of the offense, from that it will be started. Okay, so these are the general points. Now continuing offenses. So continuing offenses means what? That maybe continuously wrong has kept on happening. So the law says that you can where offense is being done for over a long period of time. Let's say if someone has taken illegal property, they are in their possession for a long time, or there is a violence going on between you could say domestic violence for a long period of time, they are called as continuing offenses. Continuing offenses means they persist for a long period of time rather than just one single point of time. Okay, so limitation periods resets every time. So let's say if there's domestic violence, so if I ask from when it has been done, so he says always there, every single day. So every day it is there. So from the latest dates, limitation period will be there, because if let's say today also he did domestic violence, of today you have so much time limit to come to the court. That's the point. Okay, so if a factory continuously discharges toxic waste into the water without permission, each day of discharge is treated as a continuing offense until it stops. Okay, with this we have completed few little case laws have been given. That is it. Okay, so with this we have completed the entire chapter. Thank you. Okay. Okay, so is this clear completely? So I have completed the entire BNS Act. Today I have completed the BNSS Act also, and tomorrow I will cover the BSA Act also. Okay, the notes for this I will rotate it in the WhatsApp group after my lecture. Okay, so tomorrow I will start with the BSA Act and complete it. Okay, and then after that, every single day till your exam day I will be there, and I will be taking fast paced marathons covering all the past important things also. Okay, so that is it for today. I will see you all again tomorrow with the third law. All these acts etc which I have done, you will get it in my dream batch. So with this I complete my session, and I will see you all tomorrow with the BSA Act. Okay, so I will be providing in the WhatsApp group. So that is it guys. See you all tomorrow. Thank you so much. Don't forget to like the video also. Take care guys. Bye. Okay, and stay tuned. Lot I have planned for you all, and fast paced things will also be done. This is just tomorrow BSA Act will be completed. Most welcome Chandra. Thank you. Thank you. I will be sharing in the WhatsApp group also this entire thing. Take care. Bye.